Okay, so we're moving into our second part two of disciplining procedures. And so what's important is that unless a disciplinary infraction is the direct result of the child's disability, in other words, what they did was caused by or has a substantial relationship to the disability, such as a child who's labeled with emotional disturbance, we know that that is obviously there's a direct correlation between behavior and disability, then the child will be disciplined in the same manner as a child without disabilities. So the law does allow for short-term disciplinary removals. And so the child can be suspended or changed to an interim alternative educational setting or placement for not more than 10 consecutive school days. More than 10 cumulative days in a school year may be considered a change of placement, and change of placement must be addressed by the IEP team. So that it's important to remember, these magical numbers in terms of school days, which local education agencies pay close attention to, and also the change of placement as well. After the 10 cumulative days of suspension, educational services must be provided, and a lot of times, they're provided before those 10 days to make sure that the child continues to be provided with FAPE. So in terms of educational services, the IEP team, if under 10 cumulative days, services can be determined by an administrator and teacher, must allow the student to receive special education and essentially receive FAPE. So that always continues, and that's just a good rule to remember. If there's a series of short-term suspensions, so this is important, for different incidents, these are permissible as long as they do not constitute a change in placement. So essentially, if there's different incidents, if there's not a pattern, and that's an important term or concept we need to remember. If there's not a pattern, then these are permissible. The IEP team must decide when suspensions are a placement change, the length of removal, total amount of time the student is removed, and this proximity of removals to one another. For long-term disciplinary removals, the student suspensions in excess of 10 consecutive days are always considered a change of placement. And change of placement, if not done according to IDEA requirements, is illegal. So again, we'd be out of compliance as in a local education agencies would be out of compliance if there's a long-term change of placement without teaming considerations. Educational services and manifestation determination are required under those circumstances. In terms of very serious incidents, we are allowed these long-term removals. They're referred to as unilateral removal of a student into an interim alternative educational setting for 45 school days if the student does the following: carries or possesses a weapon to school, so that's one reason. Knowingly is involved in selling of drugs, and has inflicted serious bodily injury to another person while at school. And so serious bodily injury is defined in the law as well. It's not just a hit or a smack, but it has to really inflict bodily injury. In that case, when there's this long-term removal, an impartial hearing officer will be assigned, and there will be a hearing to determine, this placement situation and whether or not the student's current placement is substantially likely to result in injury to the student or others. During that 45 period time, we have that manifestation determination meeting with the team to determine whether or not there's a relationship between the student's disability and his or her behavior. A manifestation determination is required when a discipline sanction could result in a change of placement. And during that, the review must be conducted by the district, the parents, and the relevant members of the IEP team to determine the relationship between disability and misconduct. If there's no relationship, then the long-term suspension and expulsion are available. If there is a relationship, then long-term suspension and expulsion are not available. So that is important, an important part of the process to determine whether or not there's a relationship between the disability and the behavior. So when the team is conducting this manifestation determination, they're gathering all relevant data. And they're asking the question, was the problem behavior the direct result of the school's failure to implement the plan? So obviously, if that's the case, then there's an issue in terms of the plan and the implementation of it. And was the behavior that led to the disciplinary sanction caused by, or did it have a direct and substantial relationship to the disability? So those are the questions that we're trying to ask and determine. During these proceedings, the child is essentially staying put, and that's referred to in the law as the stay put provision. And means that the child stays there where they are in the placement, but they are still provided with FAPE. And the family is entitled to what's called an expedited hearing. So this whole process needs to be done relatively quickly, and the hearing needs to take place quickly. So for protection for students who are not yet eligible, so this is important because sometimes a child has, a major disciplinary infraction, but they're not identified as a child with a disability. And so what does that mean? That means that if the parent expressed concern in writing, then the district could still be held liable in terms of this process, because perhaps the child actually did have a disability, but the district didn't evaluate the child. If the parent requested evaluation and it wasn't done, or it wasn't done correctly, and if a teacher or other representative from the school or district expressed concerns about a child but nothing was done, then that particular child still may have protections under the law. So there's always a question about, involving law enforcement, and school officials can report students to law enforcement. But the procedural protections are, are essentially still in place. So we have to be careful with this. Procedural protections that apply to crimes are governed by criminal law, not the Individuals with Disabilities Education Act. Law enforcement officials can obtain a student's records, though, but we need to be careful that we comply to another law, which we refer to as FERPA, which really protects confidentiality and records of children and family members. So we do have some punitive, what would be considered more punitive or reactive type of disciplinary measures that we use, and one that's written about in the literature and that some schools use is referred to as time out. A lot of times schools will call it a cooling out room or a calming out period, but essentially there are rules for how we deliver time out, and I would say the best thing to do if you're a teacher is to make sure you know what the rules are and that they're specified in that behavior intervention plan, but that you know the rules for use of timeout. In terms of in-school suspension, we still have to be careful in terms of how often we're using, whether or not it's effective. It could be considered a change of placement if the child is continues to be in school suspension. And we have to make sure the child continues to receive FAPE so that those IEP goals are worked on. So there are prohibited procedures, and those are, when we're talking about a child with disability, those are those procedures that change a placement unilaterally without teaming decision and deny the child an appropriate education, and also those that may be discriminatory and based on the child's disability. So unilateral change of placement, serial or long-term suspensions, and expulsions. And that concludes discipline.